Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. Today we discuss 3 opinions, all dropped the same day, June 30th, the final day of the October 2025 term.
3 rulings, 1 morning. Let's go. Give us the headline first.
Birthright citizenship falls 5-4. Girls' sports stay restricted to biological females 6-3. And political parties just won the right to spend unlimited money coordinating with their own candidates, also 6-3. 3 blockbusters to bookend the term.
Trump versus Barbara earns that title outright. 5 separate opinions stacked on top of the majority. A Chief Justice who breaks from his usual allies. And get this, the opinion runs 194 pages.
That's massive. It beats the Trump tariff case from earlier this term by 30 pages. That ruling already counted as a blockbuster in its own right. Barbara tops it.
So today's episode has a lot of ground to cover. Before going further, here's your reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report, and if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com. All right, here's what you need to know. Let's start with the blockbuster. January 20th, 2025. President Trump signs Executive Order 14,160.
What's it do?
It says kids born here to a mother who's here illegally, with a dad who's not a citizen or green card holder, don't count as citizens. Same goes for kids born to a mom here only temporarily. Several families sue, and here's the part that moves fast. The district court in New Hampshire blocks the order almost immediately and certifies a nationwide class of affected kids.
Then it jumps straight to the Supreme Court?
It does. The justices grant something called cert before judgment. That means they skip the First Circuit Appeals Court entirely and take the case directly.
Why skip a whole layer of courts?
Speed. This touches potentially millions of kids born every year. Argument happens April 1st, 2026. Ruling drops today.
So what's the actual fight?
3 words in the 14th Amendment. Subject to the jurisdiction. Does that just mean you're here and you follow our laws? Or does it require something deeper, like a parent who's legally settled here?
Can the president redefine citizenship just by reinterpreting 3 words? Chief Justice Roberts, writing the majority, says no.
Walk me through it.
He goes back to English common law. Old rule, if you're born on the king's soil, you owe allegiance, and the king owes you protection. Didn't matter how briefly your parents stayed. He gave us a few examples. One was Calvin's case from 1608. A foreign mother gives birth in England, leaves the next day, and her baby still counts as a British subject.
400 years old, and it still matters today.
Roberts uses it on purpose. Then he jumps to Dred Scott versus Sanford, 1857, the case that denied citizenship to Black Americans. He frames that as the wrong turn. The Civil Rights Act of 1866 and the 14th Amendment exist to fix it.
And the modern case backing all this up?
United States versus Wong Kim Ark, 1898. A man born in San Francisco to Chinese immigrant parents who could never naturalize. Court rules he's still a citizen. Roberts treats that as settling the question for good.
Now, the government wanted a domicile rule. Only kids of parents who settled here permanently count. Roberts rejects it. He says the word domicile barely shows up anywhere in the actual debates over the amendment.
Okay, final count, 6-3. Roberts writes it. Sotomayor, Kagan, Barrett, and Jackson join him. Kavanaugh concurred in the judgment.
Wait, Barrett joins the liberals here?
She does. That's the headline vote split right there. A Chief Justice and a Trump appointee crossing over.
That alone makes this worth a deep dive. And it gets deeper. 5 justices write separately.
5 on one case? 5. Start with Jackson. She joins Roberts completely. No daylight there. But she writes her own opinion just to argue with Thomas directly.
Justices arguing with each other inside the opinions themselves. Who doesn't love that? She says Thomas reads the amendment too narrowly, like it only protects formerly enslaved people specifically, instead of resetting citizenship for everyone.
Now here's a fracture worth flagging. Kavanaugh.
Right, and this is the important distinction. Kavanaugh doesn't join the majority's constitutional reasoning at all. As we just said, he concurred in the judgment and dissented in part.
Translate that for us.
It means he agrees with the bottom line. The order's illegal, but for a completely different reason. He says it doesn't violate the Constitution. It violates a federal statute, the one Congress passed in 1940, using the same subject to jurisdiction language.
So he thinks the order's illegal, just not for the reason everyone else thinks.
Exactly. And here's his kicker. He says Congress could pass a new law creating these exceptions constitutionally anytime it wants. They just haven't.
He's basically tossing the ball to Congress.
That's the read. Now, the dissents. Thomas writes the main one, joined by Gorsuch. His theory: citizenship only goes to people actually domiciled here, people who made America their permanent home.
The exact theory Roberts just shot down. Then Alito writes his own separate dissent. He argues citizenship should require full allegiance to this country alone, and warns the ruling extends citizenship to kids of so-called birth tourists. That phrase is going to be everywhere tomorrow.
Guaranteed. And then, this is the wildest fracture of the bunch. Gorsuch writes a third separate dissent, even though he already joined Thomas's.
Why write twice?
Because he doesn't fully agree with Thomas's domicile theory either. He's got his own version, what he calls an American settler's view. 3 justices, 3 different legal theories, 1 shared outcome.
So even the dissenters can't agree on why they're dissenting. That's what makes this a 194-page blockbuster.
So what changes tomorrow? For families with parents here illegally or temporarily, their kids keep citizenship. Full stop for now. But Kavanaugh's opinion hands Congress a roadmap to legislate new limits later.
This fight isn't over, not even close.
On to case 2, schools, sports, locker rooms. West Virginia versus B.P.J. With a companion case from Idaho, Little versus Hecox. West Virginia passes the Save Women's Sports Act in 2021. Bans transgender girls from girls' teams, middle school through college. B.P.J. diagnosed with gender dysphoria around age 9, starts puberty delaying treatment a year later, starts estrogen 2 years after that. She never goes through male puberty at all.
So her body develops differently than a typical biological male's. That detail drives the whole case. When the ban hits, she's heading into middle school, ready for track and cross country. Her principal says no.
And nobody even got cut from that team?
Right. Everyone who tried out made it. No roster competition at all.
Meanwhile, Idaho's running its own fight.
Idaho passes a similar law in 2020. Lindsay Hecox sues after it blocks her from women's club soccer and Division I track tryouts.
How do both cases land at the Supreme Court together?
West Virginia's district court first lets B.P.J. play, then flips after discovery and rules for the state, without resolving the actual medical dispute between the experts. The Fourth Circuit partially reverses, sends the constitutional question back for more fact-finding. Idaho's courts block their law outright. Supreme Court combines both. Argument January 13th, 2026, ruling today.
What's the legal question?
2 parts. Does Title IX ban schools from limiting girls' teams to biological females? And does the Constitution ban it?
Kavanaugh writes this one too. He answers no to both questions. He says schools can limit teams to biological females.
How's he get there on Title IX?
The law's own regulations specifically allow separate teams by sex. So separate teams don't count as the discrimination the law bans. They're built into the statute.
And the constitutional piece?
Sex classifications get something called intermediate scrutiny. Government needs an important goal, and the rule has to connect substantially to it. States say safety and fair competition. Kavanaugh agrees those count.
But what about B.P.J. specifically, who never went through male puberty?
He rejects carving out individual exceptions, says states don't need to assess every athlete's actual physical capability one by one.
The final vote was 6-3. Kavanaugh, joined by Roberts, Thomas, Alito, Gorsuch, Barrett. Both lower court rulings reversed. 2 concurrences here, both worth flagging. Thomas writes separately, arguing transgender status shouldn't trigger any extra constitutional scrutiny at all. Gorsuch writes separately too, but on totally different grounds. He says Title IX never clearly warned schools they couldn't run single-sex teams. So even inside the 6-justice majority, there's real disagreement about why, not just what.
Exactly the kind of fracture worth catching. Now the dissent, Sotomayor, joined by Kagan and Jackson.
What's her main dispute?
That the majority skips past a real factual fight. Competing medical experts disagree whether B.P.J.'s treatment erases any athletic edge. The Fourth Circuit sent that exact question back down for evidence. Sotomayor says the majority jumps ahead of it.
And she pushes back on that zero-sum framing directly. Nobody got cut from B.P.J.'s team. The premise doesn't even match her actual case.
And Jackson writes separately too. Briefly, just on Title IX, warning the narrow definition of sex could hurt transgender students in other contexts down the road.
What changes tomorrow?
Every state law restricting girls' sports to biological females just got constitutional cover. Transgender athletes lose their strongest federal argument, and states without these laws now have a green light to pass them.
On to case 3, money in politics. NRSC versus FEC. Federal law caps how much a political party can spend coordinating directly with its own candidate. Up to $4 million for a Senate race, depending on the state.
Who's challenging it?
The National Republican Senatorial Committee, the NRCC, then candidate J.D. Vance, and then Representative Steve Chabot. They say the cap violates free speech, and the precedent upholding it, Colorado 2 from 2001, doesn't hold up anymore.
How's this get to the Supreme Court?
The full Sixth Circuit technically upholds the limits, following Colorado 2.
But several judges write separately questioning whether that precedent survives newer rulings.
That kind of internal disagreement waves a flag.
Exactly what gets the Supreme Court's attention. Argument December 9th, 2025. Ruling today.
What's the actual fight?
Can the government limit a party from directly helping pay its own candidates' bills?
Kavanaugh writes this one too. Third opinion of the day for him. 2 majority and 1 partial concurrence and partial dissent.
Busy guy. He says coordination between a party and its candidates forms the core of how parties function.
Parties coordinated freely for 2 centuries with no documented corruption tied to it. What changed since 2001?
2 newer cases, McCutcheon 2014 and FEC versus Ted Cruz for Senate 2022. Both demand much stricter justification for these limits now. Kavanaugh says Colorado 2 can't survive that tougher standard.
So he overrules it outright?
Completely. He says Thomas's original dissent from 2001 has been, in his words, amply vindicated.
What was the final tally?
6-3. Same lineup as the sports case. Kavanaugh, Roberts, Thomas, Alito, Gorsuch, Barrett.
No separate concurrences this time. Everyone signs onto one opinion, clean. But Kagan pens a sharp dissent joined by Sotomayor and Jackson.
She opens with an actual Watergate-era bribery story. A milk industry pledge tied to a subsidy decision. That's the corruption Congress wrote these rules to stop.
Her central argument is that without the coordination limit, a donor can funnel $500,000 to the party, which just pays the candidate's bills directly. Same corruption risk, different door.
She offered a striking line for that. She calls the party, in that scenario, less a collaborative speaker than a simple piggy bank.
And what changes tomorrow?
Parties can write much bigger checks straight to their own candidates heading into the 2026 midterms. Expect campaign spending to shift fast.
What connects the 3 cases? Power and where it stops. Barbara asks how far the president can stretch executive power. B.P.J. asks how states balance rights claims. NRSC asks how far Congress can regulate political money.
And Kavanaugh sits at the center of all 3.
2 majorities, plus a major separate opinion in the third. Defining day for him.
Bottom line for listeners?
Birthright citizenship survives, but Congress holds the next move. Girls' sports stay restricted to biological females nationwide, and parties just got a lot more spending freedom.
Huge day. We'll continue with our coverage. We'll offer individual opinion breakdowns. So stay tuned. More to come.
Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
194 pages. I need a nap.
Rate us 5 stars first, then nap. Talk to you soon.